Welcome everyone to the next session here at the Berkeley Center for Law and Technology's Tech Tuesdays and Tech series. This particular presentation is one several years ago I don't think you would have ever come across. We're focusing on things that normally you don't hear together. M&A and national security, M&A and foreign investment you hear a little bit about. But as we've been working with our partners, we've come across just the incredible work being done at Baker McKenzie and partnered with them on this program. And today we have two folks for you here. One, Aarthi Belani from the Baker McKenzie Palo Alto office, and Rod Hunter from the Washington, D.C. office. So you see this this nice mix of big law pulling from multiple offices. But Aarthi's focus is on M&A, venture deals in the life sciences and tech areas, and does a tremendous amount of cross-border transactions. Rod is got a really interesting background you don't see on the West Coast much, but special assistant to the president for national security affairs, senior director for international economics at the National Security Council, deeply involved with CFIUS cases. Again, types of things you don't see on the West Coast. So this mix between Silicon Valley tech and this East Coast national security practice is really unique to see in this type of training program. So I want to thank you both for putting this together. I've seen the article that you put out that will be attached to this material, but something that used to be maybe a niche area now seems mainstream, and something you find in the paper every day. And I appreciate you sharing that with everyone we're trying to provide material to.
Thank you, Wayne. Thanks so much for having us. Yeah, Rod and I are sometimes at cross purposes. I'll at least for the sake of this, CLE, caricaturize myself as the rabid deal lawyer, always trying to get the deal done, and Rod over there telling me all the things that we have to be sure to clear in terms of a kind of what we call the rising and garden wall and expanding garden of protectionism, essentially. I think we all have seen the arc of how global capital started flowing more freely at the end of the 1980s and beginning of the 1990s, and as a result, lots of our companies and startups and so on have foreign investors in their ownership structure, and for a long time that trend was increasing. Beginning in the 2010s, kind of 2012, 2013, and then heightening in 2017, 2018, the government and many nation states started recognizing that there are national security interests in particular in technology and private sector companies that have government contracting relationships, and that they needed to regulate how foreign investors are invested in and receiving information about U.S. companies. And this is then also true in other countries as well. There are, other countries that have regimes governing cross-border investments and transactions. So kind of the goal of our conversation is to highlight some of the things to look for when you have foreign investors looking at investing or already in a U.S. company, particularly one that is a kind of critical technology or infrastructure or high, data processing type company. Things that have changed recently that make all of this a bit more, difficult, and things we should think about as those concerns only heighten. So maybe I'll start with kicking it off, and Rod and I can talk about how these cross-border investments, what exactly triggers national security interests. When does the regulator get interested? And I'll turn the screen share off now that we've seen kind of the roadmap here, so we can just have a conversation. So Rod, tell us what in particular causes draws the eye of Sauron, so to speak. Sorry, I'm a West Coast nerd.
No, I certainly follow that. Well, Aarti, one observation I'd make is that um, I wouldn't really describe this as protectionism, although it certainly feels like that when one's deal gets caught up in the regulatory morass that it is that we all have to deal with today. I think is a big framing comment. It's probably worth keeping in mind that the world has changed pretty substantially in the last couple of decades. I mean, you pointed out that the capital movements, capital flows have certainly increased over the last generation, certainly the last 20 years. We had the reassertion of geopolitics, which were a feature of international life, certainly through the end of the Cold War. Then we had the unipolar moment, and we all sort of forgot that there is such a thing as geopolitics, but that's come back. But what makes this era so different is the connectivity that results from technology and enhanced with data. And so since 2013, 2014, since we had a change of government in China, there's been an increasing concern in the United States, but also in other governments with national security concerns. There's a great awareness of vulnerabilities that are embedded in our connected economies. A VC famously remarked that software eats the world. Well, software brings with it lots of productivity, but also it brings with it vulnerabilities that didn't exist before. And so I think what you're seeing in terms of the regulatory response, well, is a regulatory response to this greater awareness of vulnerabilities that comes from the technologies that improves our lives in so many ways. And it's happening not just in sort of data regulation straight up, like last week, I think it was, that Department of Justice issued new versions of regulations on data security. But also today, the Treasury Department just rolled out final regulations on outbound investments. But then what you and I have also spent a lot of time on are the evolving and expanding scope of the foreign investment rules, CFIUS, which was esoteric 20 years ago when I first started dealing with it when I was at the White House. I mean, it was only really, it would even make it into a textbook in a law school. It was so esoteric. And now it's there, and within law schools, you'll have several classes on just these sorts of issues of national security. So I think that's sort of, it's driven by national security less than the protectionism, but that doesn't feel any better when your deal gets caught up with these regulations.
I remember well the first CFIUS filing that the deal where I was on a, deal that had to make a CFIUS filing, and it actually all went through fine. I think for me, it was probably 2017, and it was an ally country. And so we did have to make the filing. It was enterprise software, not something that you would typically have flagged, right, in the prior era. But we did have to go through it. It went through, it took less than a month. So, it was fine. But yeah, I think like when you have a Chinese investor or a Russian investor, it can look quite different.
Yeah. Well, I mean, you mentioned your first adventure with CFIUS. My first adventure was way back in 2003, and it actually involved a Singapore investor, so not even Chinese. Mm-hmm. And this was when I was at the White House, and my boss, Gandhi Rice, representing the president, had very clear directions, but the Defense Department had very different views. So even all the way back to 20 some years ago, not just Chinese investors, but other investors raised concerns with the security agencies. That transaction was ultimately approved with mitigation. But I think that sort of phenomenon has actually become much, much more common. Last year, I think something like 20% of CFIUS notices, the larger filings, ended up with mitigation of some form. And that's really been a substantial change of just during the Biden administration.
What is the most common form of mitigation that you are seeing?
Well, In earlier periods, there was a broad variety of everything from letters of assurance all the way up to full-blown national security agreements. The letters of assurances were often really quite limited in their obligations. But now, government being a creature of routine, these mitigation agreements all look very, very similar, and they're they're all called national security agreements. And there's some sort of standard provisions that appear in a lot of these agreements. The substantive obligations really depend on the nature of the business. So, Aarthi, for example, the software business that you were talking about, that might have some technology controls, but much more likely to be controls around data, prohibitions on sharing data from the company to the foreign investor, obligations to set up a security plan, security officer, maybe security director, and then you get the bevy of consultants who have to monitor compliance, which sort of adds to the operational burden for the tech company. And then sometimes you have small companies which are the targets of the mitigation. And as you would have seen this in your practice, some of those businesses find themselves scratching their heads about why they have to pay for a whole bunch of consultants to do something that, what was just a small startup, before they went through this, and all of a sudden they've got all these security officials hanging around.
One of the things we used to do in venture deals was, while we were, pending clearance, we'd let the foreign investor take a kind of a small, non-controlling equity or non-voting, interest, and then have a springing right to get something greater if they got CFIUS approval. My understanding is we can't really do that anymore in the situation where a mandatory filing, is required. So now were we just in the position where we just have to wait to get that approval if we want to get that through?
Yeah, no, it's a great point. It's for there's with say M&A type transactions, this sort of issue doesn't come up as much because obviously you typically get your governance rights after closing and so forth, and the closings usually takes place after CFIUS clearance. But financings, timing is often absolutely essential. And so in the market, people develop the practice of using springing rights where, the investors would commit the capital and not get all of their governance rights until after CFIUS cleared. But the current administration, the Biden administration, changed that policy about 1.5 years ago. They reread the regs in a different way than their predecessors had read the regs, basically excluding the ability to do such springing rights, which of course put a spanner in the works for a lot of financings. And now there's a way to navigate it, but it's a bit more clunky and involves more time. Basically, the way the rules work is you have to, if there's a mandatory filing, which is usually technology businesses or software, you have to do the filing, wait for CFIUS to put a stamp of acceptance on the notice, and then wait 30 days. And then after that, you can do springing rights, but you have to have that 30-day layover under the regs. So it's now, there's a way to do it, but it's not as fast, and so it creates a bit of a challenge, particularly for foreign investors, when it's if it's a competitive financing. People want to come in, and maybe the company doesn't want to wait the 30 days. And then of course that also creates challenges in a bankruptcy context where timing, financing may be really quite urgent.
Yeah. Yeah. And now we're looking at outbound investment restrictions as well, right? Particularly in the semiconductor and like quantum computing and AI sectors, because of concerns with US companies having technology transfer and knowledge transfer take place if they are investing abroad. And this is something very new in terms of particularly what I see with the folks we work with, in-house, who are often the ones spotting the issue and roping in outside counsel and regulatory counsel and just getting used to that checklist step of having to think about, do we have to go think about CFIUS notification or filings or restrictions if we are expanding a presence abroad or investing abroad or engaging in, something that U.S. companies are quite used to doing, running our operations multinationally, thinking about where makes the most sense to do development or packaging or, any of these various production steps. Where are we with that evolution? I know we first saw that last year. And this is all part of understanding that advanced computing is, again, like a national security concern. And I know there's also been lots of evasion of some of these restrictions where people route through other countries, and it's a much more serious version of what's been happening probably in garments production and, dealing with those quotas and stuff. But where are we with this? Now I've definitely seen in the past year, sometimes we've had to back away from an outright, acquisition and change it's getting very into the details of the operations now.
Yeah, so about a year ago, President Biden used emergency powers to issue an executive order directing the Treasury Department to develop these outbound rules. And just last night, this morning, the Treasury Department issued its final rules for those regulations, the final version of the regs, which will come into force January 2nd. And you're right, it will prohibit U.S. persons from engaging in certain transactions in China or with Chinese businesses for some of the sectors that you mentioned, semiconductors, artificial intelligence, and the like. And the scope is broader than just U.S. companies making those transactions. A U.S. person may not participate in such a decision, even in a non-U.S. company. So a person with a U.S. nationality would have to recuse himself from any such participating in any such decisions. And then further, this is not just for acquisitions or investments or financings. It could also reach upgrades, restructurings that are taking place that an existing U.S. company is doing with its facilities in China. So I think that's going to catch a bunch of companies by surprise. Companies that have facilities in China may find that their activities that they're planning, so-called other development in China, may trigger either a notification obligation to the Treasury Department or actually a mandatory a prohibition rather. Now there's a way to make it a request for an exception to get an approval in essence from the Treasury Department. But you would imagine that that's going to be a pretty high bar in many cases.
Yeah. And I think I'm not sure. I think this recording will probably be out there after we know the results of the U.S. election. But my understanding is, there's a fairly broad bipartisan consensus behind these types of inbound and outbound restrictions. So we can expect them, to stay with us. Would you agree?
Yeah, that's one of the few things that there's agreement on in Washington is that these concerns about national security risk, concerns about China, concerns about national security risk. And so, that's, the current administration is trying to push out a lot of its national security rules now because they don't know if, who's going to be in those chairs come January. But, you've seen, as I mentioned a moment ago, the new rules for data security, the new rules on outbound investment, new rules on security around connected vehicles, with basically banning the use in the United States of Chinese connected vehicles, electric vehicles. So yeah, there's a lot of political momentum here in the U.S., and I think you're seeing some of the same phenomenon in other jurisdictions too.
Yeah, I think you and I have both dealt with situations where even internal restructurings have been caught by foreign investment review I think in particular in the UK, where the legislation is drafted quite broadly, and we've read that rule as even requiring that where you're moving your own subsidiaries or property around internally, kind of in a corporate group, which is probably overbroad, but it's probably taking a bit of time to get that refined. But yeah, I mean, we look at this multi-jurisdictionally every time we have a multi-jurisdictional transaction, and I think it's nice that we can do that global review, and understand where this might trip in multiple, even if you're only buying the parent company of a multi-jurisdictional group, you still have to look at that at every place where they have operations or employees or subsidiaries.
No, you're right.
Yeah.
The U.S. does this too, and that if a foreign parent wants to restructure its entities, including in the U.S., if it's a critical tech business, which can include even just things as simple as encryption, that can trigger a mandatory filing, and there's no exclusion, at least at the moment. Which is crazy, but that's just the way the rules work. And as you point out, other jurisdictions do the same thing. And what there's you mentioned doing a number of multi-jurisdictional reviews. Of course, we've for decades have done multi-jurisdictional reviews relating to the antitrust side, because of course there was a proliferation of antitrust regulation from the 90s on. But what's different, I think, and it'd be interesting to hear your response to this, but my impression is what's different with the antitrust reviews is that there's a lot of commonality to the analysis across jurisdictions on the antitrust side. But if you look at the foreign investment review side, each country has its own regulatory regime, and there are often some idiosyncratic approaches and jurisdictional triggers and what it is that they're interested in. For example, in Italy, virtually everything is considered a national security issue. In the UK, it's not, you don't even have to actually have operations in the UK. If you just have contracts with the UK government, you get caught. And so in any event, it becomes a highly particularized exercise. And then
agricultural land is a big one, right? In a lot of places.
And then sometimes, of course, France being France will come up with some rather interesting approaches to what is a national security risk. But
will you allow my protectionism editorializing, at least vis-a-vis some of those countries' rules?
I think so. I think so.
Yeah, I mean, another thing that we come across is, in particular, like, let's say we have a US-based company that is compliant with US sanctions, US export controls, and they are buying a company that has not been in the US, and maybe it's in multiple European countries, or multiple Europe, Middle Eastern countries, or kind of has more of that geographic scope. And then we have to look at, is kind of like day one US compliance possible with that acquisition? And that's been a challenge over the last couple of years as well. I think there have been particular US export controls where, even again, like buying something in a quote unquote like ally country, the ally country might have different controls. And I've definitely seen some morphing of deal structure to take into account that quote unquote day one compliance, it might not be possible for sometimes like 2 years. And then we change the transaction structure, sometimes go to like a license and option, structure, just to deal with that. And I mean, I'm seeing that even sometimes where what you would call, like, I call on the route transactions, where it's like between places that are doing business with each other all the time, but now like US and the Netherlands, for example, but now the export controls framework in each country is different, or the sanctions framework, is different. And again, like you said, that idiosyncrasy can make combining a challenge.
Well, and you think of some of our the United States' recent regulations around Huawei and some others, and the rather capacious approach of U.S. export control regulation, which in theory can apply to people and transactions that have no other nexus to the United States, except for that there may be some U.S. technology embedded. And then when you add on top of that a transaction which involves a U.S. person, then obviously it creates compliance issues. And this is a world which national security regulation is just proliferating, and so I think it becomes these national security regulations just become a critical path in every one of the technology deals that has any international dimension to it, and sometimes even what seems like no international dimension.
Yeah, and you have this kind of up the chain aspect as well, because obviously there's been that's kind of always been there. That the analysis of how you determine whether someone is a foreign person or foreign controlled, and having to look up the chain, but it feels kind of emphasized now with corporate transparency. Again, that's not just here, but almost everywhere now. Another issue that I think you and I have been dealing with is investors that are already invested in U.S. companies getting, named as designated nationals under sanctions regimes. And then how do you think about getting that investor out, or just freezing their interest? That has been a new issue as the sanctions have caught, just cast a wider net, so to speak. And definitely we're thinking about, in new equity financings, trying to hardwire some mechanisms for dealing with the fact that you don't know whether someone might become, designated in the future. And it's a whole host of things that we have to think about that we didn't have to think as hard about in the past.
Yeah, well, it's this is a phenomenon. This is a little bit different from the national security regulations. The sanctions rules are often tools for foreign policy, and when having been in the room when designations were made, when I was at the White House, the focus wasn't it wasn't on the operational impact for businesses of what does designating particular individuals, but rather to the pursuit of a particular foreign policy. But in a world where, as I mentioned, no longer the unipolar moment, where foreign policy and national security issues populate all the time, we end up with a lot more designations. And you do sometimes end up with people, rightly or wrongly, getting caught up, swept up in these designations, which creates problems for businesses, particularly if the individuals are already in the cap table. And then how do you get them out? And working with the regulators, OFAC is not particularly user-friendly, so it's a challenging solution. And so the sorts of things, Aarthi, that you've been doing about planning for the future, whether it's planning for the future, the eventuality that there may be some stage in the future, somebody who needs to be removed from the cap table, building that into this transactions documents already makes a lot of sense. Just like some of our colleagues have been thinking about or advising clients on how they could future-proof their businesses in the event that there's other geopolitical conflicts, analogous to what happened in Ukraine. We have a number of our clients who are internationally distributed, and you can imagine other areas of the world that might see similar kinds of conflicts. And so setting a corporate structure so that they are adaptable for in those sorts of environments is probably good planning.
Yeah, it's a brave new world, so to speak, in many ways. I think we've covered almost everything that we wanted to. I'm just checking to make sure we didn't miss any serious points that we had. I think a big takeaway is sort of watch this space, right? Because it's continuing to evolve, and the implications will change in all of these areas. So what we're saying today might be outdated fairly quickly. And that's probably the biggest message that we have. Anything else that you would want anyone watching this to know or take away?
Well, I think your key point about this is evolving is I think the main point there. Different areas of law will go through periods of spurts of activity. You can think of in the environmental space in the 70s and 80s, there was a series of legislation and regulations that had lasting effect. A lot of that architecture is still with us today, and to the extent that there's regulatory action, it's within a narrower space in that area. I think what we're witnessing now in the national security area is the same sort of seismic changes. Now, the implications will play out over a decade, but it is a period of a relatively protean period in terms of the regulatory framework. So that gives me the opportunity to get to work with you a great deal, Aarthi, on your deals, which is always a pleasure.
Thank you, Rod. Well, it feels like the great decoupling or the great, disentangling, and deal lawyers have work whether people are buying or selling. So I guess it's in some ways it's BAU. I don't know if we maybe have to turn it back to Wayne to conclude.
Well, thank you. I mean, this is a fascinating area, and you're speaking to advanced practitioners here, but this is also one that I hope some of the law students around the country here this really is an emerging practice. It's not something that was there 5-7 years ago. So something to look at for the future, because there's going to be new work. So
yeah.
Well,
that's also a
thank you
great
both.
area to, like, whenever you're a young lawyer, I think rapidly evolving regulation is a great place to jump in, because yes, there are folks who know the history, but you can be like just as much of an expert on new regulation, as anyone else.
I think somebody pointed out if the textbook market is crowded in an area, it's probably not the right area to go into. So that one's been done. Now let's move on to the next one. So. Well, wonderful. I appreciate this. Very eye-opening. And as things change, I hope you come back. We can always share updates with the community.
Thank you, Wayne.
Thanks, Rod and Wayne.